Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. All right, so without any further ado, it is my absolute pleasure to introduce our speakers who are an absolute wealth of knowledge sharing with us today. And I'll just go alphabetically, beginning with Judge Jacqueline Connor. Judge Connor brings over 25 years of judicial experience to resolving complex legal and factual issues in her mediations. She's nationally recognized for her extensive study of juries. Judge Connor's fluency in the art of business and jury perceptions offers parties an expert assessment of the risks and rewards that they face at the hands of a jury. As a neutral, she's been able to use her experience to craft creative solutions across a wide range of civil matters, including construction disputes. And she's also fluent in Japanese, having been raised outside of the United States, so she brings an added dimension to the art of mediation of multiculturalism. So thank you for sharing your insights with us today, Judge Connor. Next we have John Hanover. John brings over 37 years of expertise to construction litigation and dispute resolution, offering unmatched experience in complex, high-value disputes. Renowned for his pragmatic and solution-focused approach, he successfully represented clients in hundreds of trials, arbitrations, and mediations involving contract disputes, schedule claims, and construction defects. As a former leader of prominent law firm practice groups and general counsel for an international engineering firm, John combines deep industry knowledge with a calm, strategic demeanor that inspires confidence. He's recognized as a client service all-star and ranked a leader in leading legal directories, and he's a trusted authority in construction law, highly experienced in resolving these complex disputes. So thanks so much for being here, John. Next, we have Ted Levin. Ted is an accomplished attorney and a registered civil engineer with over 38 years of experience in construction law, professional liability, and dispute resolution. His unique combination of technical and legal expertise enable him to effectively handle complex cases involving public and private construction projects, professional negligence, and business disputes. Now, as a mediator and arbitrator, Ted employs a collaborative and thorough approach, emphasizing preparation and dynamic negotiation to achieve equitable outcomes. So thanks so much for being here, Ted, and bringing both your attorney and civil engineer background to this discussion. And last but not least, we have Bob Mann. Bob, prior to becoming a mediator and arbitrator, was a well-known as one of the most successful construction lawyers in California. He's best known for representing the original owner of the Shutters Hotel in Santa Monica, resulting in the largest construction breach of contract and construction defect award in the California history of the American Arbitration Association. I hope your claim still stands there, Ted. It's been a while since we checked. He's the author of more than 50 published articles on mediation and arbitration, and is the author of a major technical construction book entitled Defect-Free Buildings, published in 2007 by McGraw-Hill. He also has extensive business litigation expertise and with several multi-million-dollar jury verdicts and settlements, and he's successfully mediating cases in diverse industries, including the restaurant trade, aerospace, and advertising agencies. So thanks so much for being here, Bob. And,
my pleasure.
And thank you all very much. I am going to pull up our slide deck and hand it over to you, Bob, to get us started with our introduction of today's program.
Okay, thank you, Katie, and thank you for organizing this. To all of our invisible guests, thank you very much for being here. My colleagues and I in ADR Services would like to welcome you to this first and what we hope will be a series of webinars on construction mediation. Our agenda today is to share with you some of our experiences and observations about construction mediation, the tropes, tribulations, tensions, and tactics. Some philosophical, some more practical. The goal is to make your next mediation better for you and to make you better for your next mediation. We hope you enjoy the program, and to answer your first question, yes, that's a real background here at my home office. With that, Judge Connor would like to start our discussion with the topic of what is your mediation goal?
Okay, thank you very much, Bob. You know, with goals in mediation, it's interesting because there's something unique about the ability to try to resolve in a mediation setting, something as unique as the construction industry, because there's so many variables, so many balls in the air. If everybody's not on the same page, they don't have the same goal, it doesn't quite work. And while the question seems obvious, it's not obvious at all. And I know that for myself, I have a lot of clues that I go to try to figure out how serious the parties are, how serious this person is, as to whether or not they want to resolve the case or do something else. And there's a lot of little tips I look for. For example, the lack of preparation. I didn't get a brief at all, or the brief came in last night at 11 or a half hour before the mediation starts. It's too short, it's poor, it's not shared. There's no demands, there's no offers, outrageous demands, outrageous offers, decision makers missing. All these things are feeding information to me as to what the goal of mediation is, and it does impact the mediator as to how we approach it, how we try to help you. I mean, my goal is to resolve the case for you, but I can't want it more than you do. And I got to admit that I was pleasantly surprised by a very direct way of dealing with this from Bob, who says, I just asked them, what's your goal? I never thought to ask before. I just tried to figure it out. But at any rate, there are a lot of different goals. Some are legitimate, some I think are gamesmanship. Other than a decision to resolve this is what your plan is. It makes a big difference. In cooperation, especially in construction mediation or construction defect cases where there's so many balls in the air, there's subs and sub-subs and policy issues and restrictions and then collection and resources. If everybody's not on the same page, ideally everybody is on the same page, but the best thing is to think about what your goal is. So cooperation is mandatory. Creativity is the superpower in a mediation because you can think outside the goal. And frankly, I think the strongest people walking into a mediation are the ones that actually are already thinking outside the goal. And they're the ones coming up with alternatives that cannot work in a courtroom or cannot work in the arbitration setting. So here's some of the things that I've seen, the red flags. Not necessarily red flags, but different alternatives on goals. And again, the idea is know your goal, and hopefully everybody's on the same page with the goals. One is preparing the case for later money day mediation. Today's not the day we're going to put the money on the table. Today's not the day we're going to come up with the actual number, but this is where we're setting it up. Perfectly legitimate, but please let everybody know, make sure that everybody's on that same page. Number two, trying to get free discovery. To me, that's gamesmanship. I don't think it works. It ought to be done ahead of time. It almost guarantees there's not going to be a settlement. But the idea of just trying to get free discovery and perhaps not giving up your own position is counterproductive and has to be addressed. Perhaps the third one might be fleshing out insurance coverage. Again, a suggestion that there hasn't been enough preparation ahead of time. You know, that's all got to be disclosed. It's going to come out anyway, what the restrictions are, what the limitations are, where the fight's going to be after the jury award comes in or the court decides. This is something that has to be out on the table ahead of time. My favorite, educating the other side with the weaknesses of your case. To me, that's that chest pumping where they want me to go in. Judge, go in and tell them they have a lousy case. Just tell them it's a lousy case. Well, I can promise you that maybe there's a 1% that I haven't seen, but it doesn't work. The other side already doesn't agree with you. Surprise. It doesn't work. They already have their position. It may be wrong, it may be right. But to the extent that you think that you've got it covered and it's a guarantee, it's never a guarantee. I'm sure, you know, never in my court, but you've never seen a judge get it wrong. You've never seen a jury get it wrong. You've never seen an arbitrator get it wrong. You've never seen the Court of Appeals get it wrong. Surprise me if you have some information, because let me know what that might be. Another, I think this is a legitimate goal, but narrowing the issues, trying to get the low-hanging fruit out, dealing with possibly some of the subs that are not going to be able to afford to go the whole distance or are going to end up changing names and coming up with a different company, bankruptcy on the first one, where it doesn't resolve the issues, it gets in the way, and narrowing these issues so you can really focus in a mediation and in the trial with the important stuff that really matters. It's going to make a difference. Resetting clients' expectations, that might be another one. I'm all in favor of using the judge, using me as a mediator to back you up so that your client understands what's coming, to perhaps be the bad guy. Let me be the bad guy. That's okay. I can be the bad guy so you can restore your relationship or make sure that they don't think you're on the other side. I'm sure that's never happened to you. Perhaps one of the other goals is ratcheting up the other side's costs. I think it's just this grinding is, I've seen it. Some of you have seen it, maybe some of you have done it. I think it's a discredit to our profession, and it really has no business in a mediation. But at least you need to know what your goal is. The final one is resolving the case. And ultimately, the resolution of the case, especially in construction cases where there's so many parties involved, is the only place where you're going to be able to tie all the knots and tie all the strings. Everything is done so that there's no post-litigation. Focusing on your goal will change the dynamics. It's going to let the mediator understand how best to try to help you. There's so much at stake. And, when we don't have that preparation, and you're going to hear a lot about preparation here, we've got likelihood of non-compliance. We've got no control in the outcome. Your client will have no say. Somebody else is going to drop the hammer. It makes a very bad situation even worse. And your goal is going to be pretty critical. Now we're going to turn to John for preparation.
Thank you.
Judge
Yes.
Connor, before John jumps in, can I throw one thing onto the table about goals and mediation? I think it's really important to share your goal with the mediator. I like it when I get a brief and it says to me in the brief, we think this is a tee-up day, or we think this is a money day. And I think you should share the goal with the other parties. For one thing, it takes a lot of tension out of the mediation if you do that, because everybody knows what to expect. So I apologize to John for the interruption.
No, jump in, Bob, and I think everybody should feel free to jump in. I'm sure I have comments too, but on Judge Connor's list of goals, I think what we decided in terms of preparing for this particular presentation is let's talk about how to resolve the case, because I think ultimately that's the goal that we would like to talk about and share insights on. And ultimately that resolution, I think, is something different than, in my mind, how to settle the case. In other words, like Judge Connor was talking about, what are the creative ideas about how to bring this case to resolution, as opposed to thinking about, what do I have to give up? What is it going to mean to my client? What am I sacrificing here? What are the ways to actually resolve this case, and what do I have to do to get there? And I think preparation is the way to get there. In other words, if we're talking about the risks of the case, if we're talking about the relative risks of the parties, you as the counsel certainly have to know what those risks are, and presenting those to the mediator will be very helpful. And like Bob says, knowing what we're going to do that day. How are we going to get this case resolved, or are we there to do something else? But if we're talking about resolving the case, then knowing the risks of each of the parties and sharing those risks, hopefully in a mediation brief, will make it possible for everybody to work towards that goal as the day goes on. And that brief, should be tailored first to identifying those risks that we can talk about. I know it's tempting, I know I've done it myself in the past, to litigate the case in the mediation brief. But ultimately, that's not the preparation that we necessarily need to help the parties resolve the case. What we need to know are really, in a very transparent and forthcoming way, what the risks are, what the opportunities are to resolve. Now, everybody should know and remember that the mediation is covered by a privilege set out in the evidence code, very clear. Pre-mediation discussions, as well as everything that happens in the mediation, is going to be confidential. So that's why the transparency and the credibility of sharing as part of the lead in to the mediation, and also during the mediation, will set the stage for a very prepared process. In particular, the work that you've done already in preparing defect lists, in preparing schedule analyses, in preparing cost estimates, in working with your experts to really boil down the case to what is most critical and what is most in dispute between the parties, should be shared. That information should be shared with the mediator, should be shared with opposing parties. Hopefully it's already been done, or at least by the time you're mediating, you're ready to do that, so that you really have a chance to resolve the case. I think also the mediator can help with preparing for the resolution by having a pre-mediation call, which I would hope that everybody would be willing to participate in and would benefit from. And even by having the experts participate perhaps before the mediation in what commonly has been called a hot tubbing session or some collaborative session where you're working with the experts again to define the issues and narrow the issues. Because oftentimes, if it's a complicated matter, you may not reach resolution on that particular day, but that preparation and that sharing of the information in a transparent way may narrow the issue so that you can continue to work on that, continue to do homework on that, continue communications with your mediator so that that preparation ultimately leads to a resolution. The other part of the preparation is money, because for these kinds of cases, that's really usually what we're talking about. So knowing where the money is going to come from or where you think the money is going to come from, which might mean whether the parties are solvent, whether the parties have resources, and most often, whether there's insurance coverage and how that insurance coverage plays into an ultimate resolution, whether it's tiers of insurance or types of insurance and what that actually covers. So Ted, I'm going to throw it over to you to talk about insurance at this point.
Very good. Thanks, John. Yeah, insurance is possibly the most important aspect of a construction claim, construction mediation, and getting the case resolved. Of course, the facts and the evidence that may be important to the claims are very important. But as far as the dollars, as John and Judge Connor have mentioned, and where those dollars are actually going to come from to settle the case, because that's what we're, of course, doing in mediation, are typically going to come from insurance, at least initially, before you may get to excess insurance issues or non-insured type of claims. So it's important, and the good mediation advocate will understand the insurance picture for the case, whether it's the claimant or the defendants. You must understand what the insurance aspects are and where, and chasing the money, as I call it, where the money is going to come from. There's just as a primer, a lot of people on this webinar may know this, but there's a plethora of types of insurance and insurance issues in construction cases. There's general liability insurance, which generally covers the contractor and subcontractor parties. And these are generalities, but that's why it's also important to understand the insurance picture in the case. You have general liability insurance. You've got professional liability insurance, which generally covers the design professionals involved in the project. You've got additional insured issues, which generally will relate to the relationships between the contractor parties and subcontractors, often additional insured obligations owed by subcontractors to the general contractor party. You also have project insurance issues. As you see here, there's OSIPs, which are or RAP policies, which are blanket policies, which can cover the entire, generally cover the entire contractor team for a project. But you can also have design professional project insurance on occasion, especially on larger projects. So again, it's important to understand all of these issues. And then finally, you can also have, depending on the project, you can have bonds, performance and payment bonds, especially on public work type projects. You can also have those aspects of insurance. So It's important to understand, as I say, the insurance, the type of insurance, what limits there may be on the insurance, and the positions of the parties and the carriers, especially on insurance, and if there's a reservation of rights that exist as to the insurance claims and the tenders of insurance that are made, and what those bases for those reservations of rights are. And it's best to work all this out and work it out, and the parties to exchange this information. It's all going to come out anyway. To exchange this information prior to mediation, so that a lot of time isn't spent at the mediation working through these issues while other parties wait. It's best to work through this in all the initial discussions and in the briefing and in the pre-mediation calls. Don't hide this information. Don't hide the insurance information, the reservation of rights, the limits, etc. That is the way you're going to have a dynamic and an effective mediation when you are, so you can then ultimately get to money day and get the case settled. And importantly, as mentioned here, an aspect of the insurance, the insurance considerations is the claims representatives who are actually handling the claims and making decisions. And there has to be sufficient information provided to the insurance claims representatives initially by the claimant, so to get the information to the defendants, defense counsel, so defense counsel can then adequately report to and prepare the insurance claims representatives. Because certainly if you don't have the insurance claims representatives who are going to be making the decisions and ultimately providing settlement authority, if you don't have them prepared, then that can be a non-starter and just hold back the entire mediation process. Claims representatives these days, it seems even kind of a current trend, they're even busier and busier than they used to be. And so typically it's said, even 30, 45 days, that may sound like a lot, but giving the claims representatives up to 30 to 45 days prior to the mediation, and especially the quote money day, to have them prepared to then make a decision and get the case resolved. This will help all the parties, of course, help the mediator, and will make the entire process give it a better chance for success. Maybe last, I could go on and on about insurance being, as I say, a very, very important aspect of construction mediation, and it could be the subject, possibly even for an entire seminar. But one other consideration for insurance that everybody should be aware of and understand is the limits on insurance and what insurance may or may not pay for, and the insurance limits, how insurance limits may affect the actual settlement, and that the parties, certain of the defendants may be uninsured or underinsured for the claims. For example, if you have a very large claim and there isn't sufficient contractor insurance, even if you add up all the policies, and even if you look at all the additional insured issues, that can have a definite effect on resolution if there just isn't enough sufficient or enough insurance. Another consideration, certainly with design professionals, that everyone should be aware of, is that design professional insurance policies are burning limits. They almost always will be burning limits, depleting limits policies. And therefore, what that means is that what's stated as the limit of the policy is being decreased by defense costs, expert costs, etc. So you always have to take into account, well, the design professional may have a $1 million or $2 million policy, something like that. But by the time you go through a trial, an expensive trial, there may not be, and there will not be, that amount left on the policy. So understanding those aspects of insurance is important, and what actually may end up being the insurance picture at the end is very important. And finally, limits on insurance, and maybe the most important one I'll mention here is resultant property damage for contractors, that you have to have for a general liability policy, that the claims have to involve what we call resultant property damage, where there's actual damage to other property, for the general liability insurance to provide coverage, as opposed to warranty work or repair of the work itself. And some of this can be very esoteric, and again, could be the subject for another seminar in and of itself. But everyone involved in mediation, especially the contractor parties and the claimant parties and counsel, need to understand what those limits may be on insurance or what is or isn't covered, including resultant property damage issues, because that can be a huge driver of the insurance considerations and reservations of rights and related issues for the mediation and on the case overall. And of course, as stated here, you always have to have open discussions with your client about all of these issues in advance, because having the discussions and bringing these issues up later and just on money day, something along those lines will just impede the progress and the potential for resolution.
Ed, can I add something about that
Sure,
exact
of course.
the relationship between resultant property damage and getting things done at mediation? Connor observed earlier that we're often asked to be the bad guy in the mediation, to deliver bad news. And that's okay. I do it all the time. We all do it all the time, and it's okay. But oftentimes we are asked to tell the client for the first time, guess what? The insurance does not cover construction defects. It only covers resultant property damage, and you don't have any in this case. And it causes this tsunami of emotion to wash over the mediation, because the typical reaction is, what are you talking about? What do you mean it doesn't cover the construction? Well, what are we going to do? So waiting until the mediation to explain this to the client is generally a really bad idea, because we can only do so much at the mediation to have that discussion.
And
Thanks, Bob. Go ahead, John.
I was going to say, I'll add to that, Bob, that really is part of the preparation, right, that I was talking about. Setting up that insurance picture, the way Ted has just described it, is really critical. The first point is having the right people there, meaning making sure the adjusters are actually going to participate in the mediation, because oftentimes I'll get to the mediation and we're talking to the wrong people. So those people who have authority, who can make the tough decisions about insurance, being there is really critical. Taking one step back from that, you have to prepare them for what's going to happen at the mediation. So like Judge Connor was saying, getting that analysis to them 30, 45, 60 days in advance so that they can do the work they need to do to have a successful mediation is really critical. If there's a coverage issue, we should know about that in the mediation brief, or that should be something that's fully vetted before we get to the mediation, so that, again, that's a risk that can be analyzed during the mediation. Everybody can take that into account.
I also wanted to add with Ted, you talked about the pre-mediation call. I think it's helpful for me as a mediator that we have that call after we get the briefs, not before we get the briefs. Then we know what questions to ask, we know what to focus on. And the other comment that was made is that it's all going to come out anyway. It's all going to come out. Don't handicap this by hiding something. It's going to come out, and you're just making the process almost guaranteed to fail for something that's going to be inevitable.
You know, Judge Connor, speaking of making the process fail, and one of the things that we've been asked to talk about today, which is these trends that we're seeing in mediation, I think we're seeing a lot of last-minute appearances by coverage lawyers. So we might have had one or two tee-up mediations. Now it's time for the money day, and a coverage lawyer shows up and says something like, we're not going to pay anything in this case. There's no coverage. And under the heading of common trends, this is a cyclical kind of thing, but we're seeing more resistance in the insurance industry to paying claims. So this is a this is a real issue and a very negative trend in my experience in construction mediation.
And last, that was all excellent. Thank you. And yeah, this concept of insurers showing up at the last minute and maybe taking tough coverage positions, that does, even in my experience, has been occurring more and more. And everyone needs to be aware of that. Insurance carriers is going to be tougher in on their bottom lines overall, and they're seemingly taking tougher coverage positions than they might have in the past, both on general liability as well as on professional liability claims. So it seems to be a trend overall. So best to vet these issues early, get the insurance coverage issues out, reservation of rights issues out, as Bob was saying, and if insurance coverage counsel are going to be involved, have them involved early. So as far as just the legal terrain generally, we've touched on some of these issues, but just as far as preparation and overall what counsel and claims people should be aware of and assist in making the construction mediation have a better chance for success. Certainly, you need to understand, and this would seem basic, but I've seen this in mediation where the parties aren't, especially with an early mediation, which is always admirable to try to resolve a case sooner rather than later, rather than let it fester, and especially in construction, because as we all know, construction cases can be very expensive to litigate. But understand what your dispute resolution provisions are and what venue you're in, and know where you're headed. As I say, especially for an early mediation, are you in arbitration? Are you litigating the claims? Is there some sort of hybrid that exists? Possibly you can have mediations I've handled. I've had this where some of the parties have arbitration clauses and some of the parties don't. So if you don't get the case resolved early, then you're going to be off and have maybe the design professional team is going to be arbitrating the claims with the owner, and the contractor is going to be in litigation. So that can greatly affect how the case will proceed. So you need to understand, of course, your dispute resolution provisions and venue. I'm going to address contractual clauses last here, because those are probably the most important part of at least this my discussion here. Again, sort of in the vein of insurance, contractual clauses in construction claims are very, very important, and the risk transfer. So you should also know whether there are bonds involved. I mentioned this earlier, surety bonds, such as performance bonds, payment bonds. You see those often in public works claims, but you should understand the surety landscape of the case and the project to know where you're headed towards a resolution. Post-judgment considerations, I'll discuss this a little bit further in a later slide, but as far as the viability of the claim and the recoverability and the judgment proof aspects of the parties and the defendants. But of course, you need to understand, and this sort of even relates to the contractual issues, contractual provisions, but are there attorney's fees provisions, and where is the case headed in that respect? As I'm sure most of the attorneys know on this webinar know that attorney's fees can often drive the resolution of a case, and they can take over the case. So you need to know what ultimately where you're headed in the end, Is there interest for how is interest and interest on a liquidated claim going to affect the claim and potential recovery? Prompt payment statutes, those are just in general are statutory provisions that allow for payment of penalties if specific parties to a construction project aren't paid. Usually they relate to claims and non-payment claims between contractor and contractor parties, although there are design professional prompt payment statutes, but these are statutory. They can be a little bit tricky, and they result in payment penalties. So you should also be aware of those. So all those are all considerations. Just understanding as it's say here, the legal terrain of the case and where it's headed and how those might affect resolution. And possibly, at least in my mind, the most important aspect of all this is the contractual provisions, and especially indemnity. You have to understand, have to know what the indemnity provisions and the indemnity rights are between the parties and what is contained in their contracts. And the first thing everyone should do is when they're writing their brief is send to the mediator the contracts, the relevant contracts, and highlight these provisions, including these indemnity provisions, because they can affect settlement. They can affect whether separate settlements can be reached, and of course, whether good faith settlement is available under CCP 877.6. And so understanding the indemnity and the defense obligations, including under the Crawford case and UDC cases, et cetera, is very important. So you got to understand your indemnity and what's in your contract, because that, especially in a construction case, a construction project where risk transfer is paramount, is extremely important. You also, of course, as we've mentioned, attorney's fees. You need to understand if there's contractual attorney's fees or statutory, but typically contractual attorney's fees provisions, because those can drive the case. You need to understand limitations of liability. You know, if there are limitations of liability, I can't tell you how many times I've gone into a mediation and the parties don't even know that there's caps on liability, limitations of liability, which especially can be existent in design professional contracts. You need to understand those provisions and how that will affect resolution of the case. And then waivers of consequential damages, which appear in many contracts, and including many reform industry agreements, such as American Institute of Architect agreements. There's a waiver of consequential damages, and you need to understand the scopes of those and how compared with the claims in the case. And when you know all of this, then you can use this as the basis to get the case resolved and ultimately get with the claims people and get with the mediator and get to a money day and resolve your construction dispute.
Thank you, Ted. I'm going to talk about the use of experts. Just before I do, I'm going to disagree a little bit with Ted on one issue, which is briefs that give me the entire contract. I'll be very transparent. I usually don't want to see the entire contract. What I would like to see is, if you think that there are some important provisions, put them in the brief. But you know, the AIA general conditions contract is 25 pages long. Unless you want me to read the whole thing, there's probably no point in it. So I think it's better to highlight those contract provisions that you think are essential to the determination of the case. Now, having said that, experts in construction. All construction cases are expert driven. Unlike personal injury cases, maybe business litigation, commercial disputes where there might be an expert component. These are expert-centric cases. Forensic experts who talk about the defects and the mechanism of failure, sometimes the methods of repair. Repair experts who talk about scope and method of repair, sometimes cost of repair experts, standard of care experts in design professional cases, delay and disruption experts, that we could have a whole seminar, I think, on delay and disruption claims, and it would take at least an hour and a half. So how do we use these experts effectively? That's the question. Well, the first thing I would say is experts have to be prepared, they have to be credible, and they have to be articulate and persuasive. They can know everything about the case, but if they can't persuasively articulate their findings and conclusions and views, they're not going to be effective. And you have to give them the tools to be prepared and effective. So they have to have access to the site. They have to have reports. And you need to make them available to the other experts in the case. This is a common theme. One of the things that we're talking about today is themes. One theme, if we could get just a few sort of important themes across, one of them would be transparency. This is an overriding umbrella, overarching theme in effective construction mediation is transparency. Don't hide these experts. I've often had people say, well, I'm not going to disclose this because there's been no designation of experts. Well, if you're not ready to disclose it and talk about it, you're probably not ready to mediate the case. It needs to be exposed and transparent. In line with that, it's important, especially in a construction defect case, to publish your defect list and cost of repair as soon as possible. And it's got to be detailed, and it's got to be authentic, and it's got to be credible. Because if it's not, it's a waste of time and energy. Make your expert available. Focus your expert on resultant property damage in a construction defect case. Experts show up at mediation all the time and want to talk about all the defective work, which is great, except defective work without resultant property damage isn't covered by insurance. So it's all well and good to talk about it, but it's not going to get us anyplace. Publish the expert reports as soon as you can. John Hanover talked earlier about pre-mediation expert meetings. I think these are really, really important. These come in two flavors, facilitated and unfacilitated. Facilitated means a mediator shows up and sort of helps everybody through the discussion. Unfacilitated mean the experts have at it without anybody. I will make an observation which might be a little bit uncomfortable or controversial. Lawyers sometimes say to me that they want to participate or attend the expert meeting. My answer is usually, I prefer that they do not do so. Because my experience is when you have an expert to expert meeting without the lawyers being present, so people don't have to perform like barking seals, we get a lot more accomplished. These experts ordinarily know one another. There's in California, at least, I don't know about other parts of the country, but here, especially in Southern California, there's a limited group of experts. They know each other. They've all worked together for many, many years, some of them. And when they get together and they can have a reasonable discussion, they can accomplish something. They can narrow issues, they can agree on issues. But if the lawyers are there, I think it just gets in the way. The other thing about experts is I dislike this expression, but I'm going to use it anyway because I think it's appropriate. It's important that they stay in their lane. Experts who get out of the safe driving lane, I think, generally get into trouble. I know some experts that I see over and over again in mediation who decide that they are the lawyer, the judge, the jury, the executioner, all combined, instead of just showing up and saying, this is what I think is wrong with this building, or this is why there was delay, or this is what the damage is to this building, and this is what it's going to cost to repair it. I think that this overreach, this getting out of the safe lane is very destructive to the process and should be discouraged. Under the heading of overreaching, the effective use of an expert means set realistic goals and expectations. An expert who comes in in a case that everybody can see is, just to pick a number out of the air, is $100,000 case and says it's all worth $1 million, that party, that lawyer, that expert is going to have no credibility. And credibility, this is another theme, just thematically, that's so important. Credibility is everything in mediation. You have to have credibility with the mediator, with the other parties, with the insurance adjusters, with the other lawyers. Credibility is essential. And credibility depends on some of these other things we've been talking about, including preparation. I think we're ready.
Okay, I guess I'm going along the same themes about reasonable expectations, but it does make a difference. And I agree about credibility being everything. It impacts the willingness of others to bend a little bit if they think that you're being reasonable. It impacts the approach of the mediator. And setting those expectations also reflects back on some things that John and Ted said about understanding what the law is. But the bottom line with mediations is that there's no winners. As far as I'm concerned personally, there's no winners in litigation. There's just an end. There's just an end. But other than perhaps we lawyers are the winners. But trials don't resolve, litigation doesn't resolve. There's always something hanging on the back end, additional litigation that of course benefits the lawyers. But the expectation, the reasonable setting of expectations, including have to include the fact that none of the parties involved in construction defect, and there are many, many, none of them are in a vacuum. They're all kind of set against each other and with each other in the same framework with each other. And it's not necessarily a zero-sum game, especially in mediation. But thinking outside the box is available in a mediation. It's not available in litigation. If there's an idea that somebody comes up with, and I think I mentioned before, be the one that comes up with the alternative within the reasonable expectations. Be the one that comes up with a different idea or comes up with something that's perhaps the carrier might just go for, even if the letter of the policy doesn't allow it. Fairness is irrelevant. I will confess that what I do in my mediations, I just say, look, fair is a 4-letter F word. There's nothing we can do about it. It doesn't belong here. The same thing with justice. Basically, we're looking at the letter of the law and what the law says, and whether it's fair or not. It was determined maybe 200 years ago, 100 years ago, with a situation that had nothing to do with what's happening today. The parties need to know that the case is ripe for mediation. I think either Ted or John talked about doing it early. Early litigation or pre-litigation may be an option when you have some smaller cadre of subs or something you can just knock out because they're not going to last the whole war anyway. And it's a perfect opportunity to do that early on. But early on for some mediations is a death knell. The foundational information has to be provided. The foundational events have to be provided. The important inspections, the sharing of the inspector's reports. The client has to know, and this has been mentioned already, the client has to be prepared to understand the limits of the coverage, the limits of what others are willing to do, and understanding that everybody has to have their needs met. There are no winners here. Critical parties have to be there. The information has to be timely exchanged. Sandbagging, coming in with a huge demand or sticker shock is of no value. And I think Bob talked about the trend with adjusters. I'm finding even the adjusters aren't always telling their own attorneys what their authority is. That never happened before, but this is something that I'm seeing more and more often. Emotional issues have to be addressed. We cannot accommodate them for the most part, but I think they have to be acknowledged. And one of the good things about a mediation is a great place for somebody to rant and rave. It's a free place. They do not get it in litigation. They won't get it in the courtroom. They might get a little bit more in an arbitration, but they do have to be addressed. And perhaps some of it can be, the mediation session can be used for that. I think Ted mentioned, and Bob did too, the resultant property damage concept has got to be understood. Basically, secondary damage, such as the flooding because of a property because the pipe broke. Well, the pipe broke because the beam shifted and the beam caused a crack in the pipe. And the secondary damage is the flooding. The primary is from the beam cracking. Some of that's covered, some of it isn't. Sometimes only the secondary is covered, but not the primary. That needs to be understood, and the client shouldn't be surprised with that limitation up front. That's got to be determined. Emotional distress damages. I'm sure Bob and John and Ted all have these situations where someone comes in very, very angry, very emotional. I just had one the other day. Everybody, all the others were pointing fingers at the one guy, the last person to install the very expensive Toto toilet. He absolutely was refusing to go down that road. He didn't have any consent privileges with Carrier, but it almost derailed the entire mediation. But he needed a chance to say and to be respected for his position, then to understand, look, you may be right, but and that has to be addressed. It has to be understood again that rule of thumb is economic damages only. We do have creative lawyers. I know a few who will bring up intentional infliction or negligent infliction of emotional distress and try to weave something in there under a tort. But that doesn't belong in a mediation, even if it doesn't, whatever they want to do for strategy or tactics in the trial, it does not belong in a mediation. Defective work product, another legal limitation that needs to be dealt with respect to the client and expectations. It's generally not insurable. These are damages when the product itself was not properly manufactured. Maybe it's a design defect, inadequate instructions or warnings. But coverage under CGL are not usually covered by the defective product, or it does cover the damage from it, but not the defective product itself. And it shows up in the policy as your work exclusion that has to be identified. Perhaps there's separate coverage for faulty workmanship or coverage for product liability, but that has to be flushed out in advance, not be a surprise with the client who just left hanging. So John, I think you need to go to know your case, which is kind of what we're all talking about.
It is what we're all talking about, and I think we could probably condense at least the first 9 slides into know your case and the facts and the law and the damages and key documents. So I'm not going to talk so much about that because I think everybody gets the picture. And I think, the picture that everybody probably is coming away with at this point is construction cases are complicated. I mean, there was at one time in my career where people, I think, thought that construction cases were not that complicated. And I always dispel that. They're incredibly complicated. The contractual provisions are complicated, the indemnity, the risk shifting in the contract, the insurance issues, all of that, and working with the experts who are critical, all of that is involved in trying to know your case. But knowing your case in that sense would prepare you for litigation. It would prepare you for your motion hearing. It would prepare you for your trial. But there's more that needs to be done to know your case if you're going to prepare for mediation. The most helpful, I think, and the most successful mediations are the ones where the parties and the lawyers have really analyzed that information and appreciated what the risks are. One way to think of it is, what am I willing, or what would I recommend to my client that my client pay to get answers to all of those very difficult questions? Because if the mediation is not successful, that's really what you're doing. You're paying to get answers to those questions, as opposed to trying to appreciate the risks and own the risks at this point in the process to get to a resolution. And to do that, that means you have to be really honest, really clear-minded about what those risks are. Talk to your client about those risks so that you can get to what it's going to take to resolve the case, where you might be willing to go and should go to resolve the case. Factoring all that in, you then have to layer in what those intangibles are, because I think that's part of knowing your case as well. It's just not these risks that are going to be allocated between the parties, but there may be special provisions about getting a default provision, for instance, change from a default termination to a convenience termination that might be of incredible value to your client. And there are other intangibles about what commitments the key witnesses might have, and it's going to prevent them from participating in the trial or participating in the continued negotiations. What value is there to having certain resources on other projects and moving that to other parts of the construction business, as opposed to devoting those to litigation? And so trying to analyze those, I think, is all part of knowing your case. Then knowing your case and sharing that with the mediator is what's going to bring the result that you really want. I know it's also tempting to say, like Bob was saying, well, we're not at that stage of the case. We don't want to disclose expert reports because we haven't designated experts, or we're keeping these insurance issues to ourselves. At the very least, you have to be transparent with the mediators, with us. Otherwise, we can't figure out how to get to some resolution that makes sense for both parties. And so knowing your case is one thing, owning it is another thing, and sharing it, at least with the mediator and with the other party as those negotiations progress, is really critical. So from there, I think we go back to Bob.
Thank you, John. So following up on some of the things that John said, I think he's absolutely right. This is all about risk analysis. So what's the underlying real concept of mediation in construction cases? It's risk analysis. I think in most cases like this, it's 95% risk analysis, 5% personalities. Personalities means managing expectations. It means allowing people to be heard, as Judge Connor said, which is a very important part of this process, even though we're not going to litigate the case in the mediation. It may be the only opportunity that people ever have to tell their story. And a lot of times, especially in residential construction, but certainly not exclusively in residential construction, these cases are very, very emotional. And people need the opportunity to vent and kind of get it off their chest and talk about it. It's interesting to me, and I'm going to try to make this brief because I have my eye on the clock, because we're about halfway through our slides, but we're way more than halfway through our time. So I'm going to do this as quickly as possible. It's interesting to me. Construction mediation is all about risk analysis, but it's fascinating how often the parties and the lawyers are resistant to the risk analysis of the mediator. And it's fascinating because that's what you're paying for. I mean, you come to us because we have decades of construction experience, and we're a third party who's objective and neutral to help you analyze the risk. And it's astonishing to me how often I might say to somebody, I'm really worried about this part of your case. And the reaction is, well, I'm not. Or, oh, we've thought about that. We're not worried about that. And I'm thinking to myself, you ought to be worried about that. So this is a two-way street. Our responsibility, our job, is to help you analyze the risk. Your responsibility and your job, how do I say this in the most polite way, is to listen and to be open to appreciating that maybe there is a risk in this case. And then let's all work together to see if we can manage that risk by making a settlement that we all control and not leaving our fate in the hands of some third party. So with that having been said, I think we go to the concept of sharing briefs.
Yes, I'll try to keep this brief. Thanks, Bob. Because of in the interest of time, we can get through our program here. Yeah, it's important. We've touched on this. I think everyone, all the speakers have discussed this. That it's important to share your briefs, share information if you're going to make the mediation successful, and allow us as the mediators to help you, as Bob was just saying, get your case resolved and to utilize our knowledge and experience in construction cases to help you work towards a resolution, to provide us a brief. Certainly, it's disappointing whenever as a mediator I see that party hasn't submitted a brief. Judge Connor discussed this early on. That's always a bit surprising that if you aren't that invested enough even to write a couple of pages, that's surprising and disappointing and telling. But always submit a brief. It's best to share it with the other side, with all the parties in a multi-party mediation, so that all the positions and important positions are known. You don't have to tell all of your secrets. If there are secrets, if there's information that you want to disclose confidentially to the mediator, then you can do that in a separate brief. Strike a balance in a complex case. delay case, for example. If there's a mediation brief is submitted, it's only 3 pages. That's telling that that's not going to cover the issues, and there's more at play, and enough sufficient thought hasn't been given into the issues. And at the same time, maybe a more simpler case, maybe a few issues, a roof leaking case or something like that. We've got 15 plus pages. It may be a little bit overkill too. You want to be careful of that. Just importantly, we've touched on this, but include all discussion of the important information as to insurance and insurance issues that are existent, any damages issues and limits or considerations as to the damages and what what may be recoverable, what may not be recoverable, including resultant or warranty work product versus warranty work product claims. Again, contract issues, contract provisions such as indemnities, limitations and liability, liquidated damages provisions, especially in delay and related owner contractor claims. We haven't touched on this much, but liquidated damages can be very important. So all of those important contract issues and contract provisions should be addressed in the brief. And finally, provide a potential resolution. You can do this confidentially in your confidential brief with the mediator, or you can do this on your what I call the public brief to all parties, and say, here's how we think this case should resolve. And that can be a huge step towards making the mediation productive and assisting us as the mediators to help you. Next is Bob and what we call common tropes in construction mediation.
So I'm going to run through this really rapidly. There's a lot of common tropes in construction mediation, but I want to focus on just one of them for the purpose of this discussion, and that's delay damage cases. So I'm going to just run through this really quickly. And my goal in discussing this is the idea, the concept of these common tropes. We're hoping to give you something that you can expect in mediation, because when you expect something, you can prepare for it. So if you're unprepared, it's hard to deal with in mediation. If you're well prepared, then it becomes much easier, and it gets to a much more effective resolution of the case. So in thinking about delay claims, we see typical arguments from contractors and owners all the time. Contractors typically argue the following about delay: defective or deficient plans, non-responsive design professionals, differing site conditions, owner-directed changes in the scope of work, owner delay in approval of change orders, owner indecisiveness, owners who can't make up their mind, owners who don't make timely progress payments, no money, no work, owners who have unrealistic expectations. They want things to be better and better and better. Owners who act unreasonably, changes from governmental authorities such as building inspectors, and late or no pay, owners who run out of money. The flip side is, what do owners argue? Owners typically argue contractors are working outside their area of expertise. They don't know what they're doing. They underbid the job. They didn't read the plans, or they didn't understand the plans. They have a lack of supervision, or their supervisors are inexperienced. They don't man up the job. There's too much turnover in personnel. It's what's called the revolving door phenomenon. There's a failure to buy out the project with subcontractors, poor scheduling of subcontractor work, poor communication, and this happens frequently. A dispute breaks out, it's resolved, and then the job progresses, and both parties say that's all been resolved, when in fact the issues have not been completely resolved. So if we could go to the next slide, because this is related. So there are some common tropes in change orders as well. So just very, very briefly, under the heading of change orders, Change orders are a big deal in construction, either residential or public works cases. It doesn't make any difference. The cases almost always arrive at mediation in the same kind of setting. Contractor is claiming money for a bunch of unpaid change orders. The owner says, look at the contract. The contract says you're supposed to have a change order before you do the work. And if you don't have a change order, you don't get paid. So what it creates is a clash between law and equity, between contract and fairness. The fairness part is, of course, the contractor has done the work and the owner benefits from the work. There's labor and materials sitting there and the owner is getting the benefit. The legal fist, if you will, in this clash of law and equity is the contract says what it says. This is especially a challenge in public works cases because the Opinski case. Opinski says at kind of the very bottom line, those contract provisions mean what they say and they're enforceable. But Opinski is not a private works case, it's a public works case. But it's the same concept in private works cases. It's that clash between law and equity. The risk this creates is simple. You might know a lot about your judge, jury, or arbitrator, but you'll never know one thing, the most important thing. Is this person who's going to decide this equity or legal? Are they equitably minded or legally minded? It has a tremendous impact on the outcome of the case. And it's something that you have to be very, very careful to think about and very careful to help evaluate the risk. I think our next topic is
delay and
delay.
LDs, Bob.
Related
Yep.
damage.
So as you just mentioned, Bob, the delay is usually a critical part of a construction case, and it's very complicated. Typically, the result of an expert battle that goes on for months, if not years, about trying to determine the critical path, trying to determine concurrency, if there is any, by the owner or by the contractor. And so that battle gets us down to a battle of the experts that's probably unresolvable, where we're not going to come away with some schedule that everybody thinks is probably an accurate representation of what happened on the job. So what do those damages look like? Everybody needs to consider kind of the what ifs that result from the different methods of analyzing that schedule. And looking at that, one part of that typically is an LD's provision, liquidated damages provision. If it is, then you need to first evaluate whether that is enforceable, or is there a risk that it's not enforceable? Or if there was a termination, does that mean that the LD's provision no longer applies? Because then you have an infinite period of time and not a finite period of time like the LD provision was contemplating under the contract. So whether it's enforceable is one risk. Whether there are other damages that may be recoverable, either consequential damages or potentially, other insurance provisions that might apply. Typically, LDs are not covered by insurance, so you may be searching for a way to recover damages that are related to delay, and something you absolutely have to know and own. Is there a provision in a public job of a public contract 7102 and delay damages? How does that impact the LD's provision? So I can't go into it in any more detail because we want to move on, but suffice it to say, it's a really complicated topic, and you need to come away with owning that part of your case and what's going to happen in the delay analysis. Ted, I think you were going to talk briefly about attorney's fees.
Yeah, attorney's fees, prompt payment. We touched on this. I think everyone has talked about this to some degree. But again, the overarching theme here, and especially in construction cases, because the complexity and the expense that can be incurred with attorney's fees and even experts, to the extent that that those fees may be recoverable, is where you end up with a Pyrrhic victory, and you could win the battle and lose the war, which is You could be the prevail on some issues, but maybe not prevail on all issues. And how much money are you and your client and the insurer going to spend in litigating a case? And then in the end, possibly having to pay the other side's attorney's fees if there's an attorney's fees provision. So this all wraps into just the issues and the concepts of understand your case, understand your contract and contract provisions and limitations, and are you going to have other contractual type considerations as well as even statutory considerations that are going to affect the end result of the case and may end up with, as I say, a Pyrrhic victory where you've got possibly attorney's fees, exposure, prompt payment, statutes, and those penalties. If there's payment claims that are existent, how's that going to affect the case, and even interest and post-judgment interest, especially on liquidated claims. And so, all this is fodder for the mediators, for us, to help you get the case resolved and take all this into consideration and to be realistic. You can have good position on a lot of the issues, but you may end up with sometimes victory which may not be financially viable if you have to end up paying the other side a bunch of money for non-damage, defect, delay type claims, the direct damages.
So in the interest of time, I'm looking at the clock. With everybody's consent, my colleagues' consent, I'm going to skip oversimplification and closeout disputes. I might say one word about closeout disputes. They're very, very emotional because they're fights between contractors and owners and everybody's upset. But I think that we should give Judge Connor the last word to talk about effective mediation and give some takeaways.
Okay, I was figuring you'd never get to me, so it was okay, but it's kind of a repetition of some of the themes. We talk about the themes that Bob mentioned. Obvious ones, preparation, it's critical. Disclosures, put your cards on the table. There's no benefit to hiding stuff. It's going to come out later on at a point where it's going to cost you more to try to resolve it or address it or get a resolution. I think with mediation, there is a huge opportunity of thinking outside the box by coming up with sometimes just an apology. Bob says it's always personal, or it's often very personal. I think it's always personal. It's always personal when it comes down to it, and the accusations hit pretty hard, and the damage from real litigation where the attacks are constant, the integrity is being maligned at every stage is immeasurable, no matter whether they win or don't win. If there is an impasse, I think the critical thing that we can provide as mediators, say, what can I do to help you? How do we move forward? I've heard some people call it homework, but for me, it's like planning for the next step. What was missing? If what information was available? If we'd had it, we could have jumped over this glitch. So providing that information. Maybe you need to have the judge rule on one of those glitches. Judge, would you please make a pre-trial decision on the issue of this coverage or your view of blah, 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 or maybe even give a tentative, just something to get the people rolling. On credibility, I think credibility is critical. It's everything. And that includes admitting the problems you've got. That includes acknowledging that you've got weaknesses. Don't insist, well, we don't think that's a problem, as Bob said. We don't think that's a problem. Well, if the mediator's bringing it up, it's probably a problem. And we've seen it all. I don't know how many years, I've got my 45 years in, and I know it's always personal. I feel like we're in the war zone and there's really no winners, and it hurts the clients. We're used to this. We're the gladiators. We're okay fighting. It's not our blood that's spilled, though. It's our client's blood. And I think it's part of our obligation as professionals to make sure that we're counselors as well as pit bulls. Sharing the briefs is absolutely critical early on. Maybe even, as I mentioned earlier before the pre-mediation call, even if it's not mutually exchanged, share your brief. You're telling the other side, look, I'm ready. I'm prepared. You're not going to roll over me. I'm not going away. I'm ready. Let's talk. I'm trying to be reasonable. Also, I think it's critical. It's helpful for me when I talk in a pre-mediation call or when I talk separately with counsel as the mediation is starting, is tell me about the process. Who's not getting along with who? Who's who? What do you think the driving issue is? Who's the problem? Is there a client control issue? Is there some quicksand you don't want me to step into that's not going to help you? How do I help you? Tell me what you need. Tell me what the background is. What's the prior mediation? What are the discussions? What's going on? All that stuff really helps towards leading into a successful, and I love the idea, instead of settlement, a resolution, because that's what we're looking for, a resolution.
Thank you, Judge Connor. Thank you to all of our speakers. We are at our time stop here at 1:15, so I do want to be mindful of everybody's afternoon. Thanks, Bob, for jumping us ahead there so we could close out with our final takeaways to wrap everything up. Thank you all four for sharing your expertise this afternoon, for giving us your insights about these construction matters. We really appreciate it and look forward to the next installation of this kind of topic area.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.